In today's video, we're gonna dive deep into a real-life traffic stop that escalates into a DUI arrest. We'll analyze the actions of the officer and the driver, break down their decisions, and explore the broader society implications of such encounters. By the end of this video, we will provide ratings and critiques of everyone involved, supported by legal statutes and practical analysis.
Good evening, I'm Officer Flame, Palm Beach Gardens. The reason I pulled you over is you're going 71 miles an hour.
Oh.
You have your license, registration, insurance?
I'm so sorry, sir. Oh.
Where you ladies come from tonight?
I gotta go to the bathroom so bad it hurt. Oh my God, It hurt so bad.
The interaction begins with the officer pulling over the driver for speeding, clocked at 71 miles per hour. This is already a legal justification for the stop under Florida Statute Section 316.183, which regulates speed limits. The officer's professional tone and approach, such as asking for the driver's license and registration, align with procedural norms. Notice how the driver immediately apologizes and mentions needing the restroom. While this could be an honest excuse, it also creates ambiguity. Was this a genuine reason, or an attempt to deflect from potential impairment?
If you are going to step out me real quick, I want to make sure you're all set to drive. We'll have you on your way home, okay?
What do you mean set to drive, sir?
Make sure you're not under the influence, okay?
Oh, I'm not under the influence, but I'm scared right now. So why would you think I'm under the influence, sir? Hi.
Hey. Make sure you're not under the influence, okay?
Oh, I'm not under the influence, but I'm scared. He's looking in my purse.
No, I'm not. Because I can smell it, I can see it, and...
You see it? And smell what?
Well, your speech is slurred, your eyes are watery, I can smell it coming out of the car. So if you are going to step out, we'll make sure you're all set and
As
we'll
the
have you on your way
officer
home.
continues, subtle signs of impairment emerge. The slurred speech, watery eyes, and the odor of alcohol are key indicators cited by the officer. These observations justify transitioning the stop into a DUI investigation under Terry v. Ohio, 392 U.S. 1, 1968, which allows an officer to expand an inquiry based on reasonable suspicion. However, notice the driver's reluctance and fear. This is where the interaction starts to escalate. The officer repeatedly asks the driver to exit the vehicle, which is lawful and necessary to ensure the driver is capable of safely operating the car. Non-compliance at this stage often raises red flags for officers.
Hands are on their guns, so please go ahead and step out.
Hands are on the wheel. I don't have
Yeah, we
any
can see
hands.
that. Our hands are up too. Let's go. Please step out, ma'am.
Wait,
Please come on out.
I'll come out.
You're not doing it,
Please
though.
don't touch
You're not
me.
doing it.
I'm just afraid. I'm just
Let's
trying
go.
to turn it
Come on
around.
out.
Put this on me.
You've already got 2 cameras on you. Go ahead and step out. Let's go.
Oh
The
my
driver
God.
refuses to step out, citing fear and claiming racial bias. This introduces a sensitive dynamic to the interaction. The officer responds by invoking Taylor warnings, established in State v. Taylor, 648 So. 2D 701, FLA 1995, which informed the driver that refusal to comply could result in arrest. These warnings are critical for DUI investigations, as they provide transparency and outline consequences for non-compliance. However, the driver's continued refusal complicates the situation further, showcasing a breakdown in communication.
Okay, time out. You need to listen right now, okay? You're being advised of your Taylor warnings. If you do not cooperate and participate in these exercises, you are not going to dispel my concern that you're driving under the influence of alcohol, chemical, or controlled substance. 1015. You're under arrest for driving under the influence of alcohol, chemical, or controlled substance.
I'm under arrest for what?
The officer demonstrated professionalism by explaining procedures and maintaining a calm demeanor despite the driver's resistance. However, there were moments where clearer de-escalation tactics could have been employed. For instance, addressing the driver's fears directly and providing reassurance might have calmed the situation. Body cameras, as mandated by public transparency laws like Florida Public Records Act, Section 119.071, ensure accountability, allowing us to critique both parties fairly. On the driver's part, repeated non-compliance and accusations of racial bias, while potentially valid in broader contexts, hindered the investigation. Failure to follow lawful commands under Florida Statute Section 843.02, resisting without violence, provided grounds for escalation. However, her fear points to a lack of trust in the system, a concern that must be addressed at an institutional level. This case raises significant questions. How can law enforcement improve trust and de-escalate tense situations? Florida Statute Section 943.1718, which mandates cultural competency training, could play a role in bridging these gaps. Additionally, public understanding of laws like implied consent under Florida Statute Section 316.1932 can help reduce misunderstandings during traffic stops. Education is key on both sides to prevent unnecessary escalations. Let's rate the key participants. The officer, 8 out of 10 professional and lawful, but room for improvement in de-escalation. The driver, 5 out of 10 fearful and resistant, which hindered the process. However, societal mistrust is a valid concern. The system, 6/10 legal standards were upheld, but systemic issues like bias and fear must be addressed. Ultimately, this case underscores the importance of mutual understanding and compliance. Let us know your thoughts in the comments below. Should the officer have handled it differently? Could the driver have acted in a way to avoid escalation? Your feedback is valuable.